back to First Issues. We continue our series on estate planning and drafting of wills with fiduciary specialist Refilwe Mogwe. In a previous segment, she spoke of the first step to drafting a will as gathering the essentials, which includes identifying your assets, being aware of your liabilities, and anything else that you feel should make part of your will. Now that you have all that in order, what is the next step? Refilwe explains this as making it legal. Refilwe, thank you for coming back on First Issues once again. We're continuing our conversation on estate planning and wills, right? Today we're talking another key step to successfully drafting a will, and the next one is make it legal. So how do we make a will legal? Get a piece of paper. So how do we do it?
Yeah, so in terms of our laws, for you to actually confidently and validly say that you have a will, we have what is called the Wills Act. And it's one of the smallest pieces of legislation, but very important, because it's basically saying this is how you do a will. Right, so it will speak about what a will is and who has the capacity to actually have or do a will, and in terms of the act, it's like 16 and above. But of course, it's adults who normally get into such conversations, so that's just something to appreciate. And then it also talks about who can be a witness in your will, right? And these are people who are 14 and above. Also, it makes mention of who cannot witness a will, right? It's important to understand that if you are a beneficiary, and that means that if my parent has mentioned me as a beneficiary in his will or her will, then it would be undesirable for me to be a witness. Mental capacity is also important. So if your client is on their deathbed, or your parent or whomever, and maybe they are heavily medicated, a bit loopy, they may not have all their full mental, faculties operating. So mental capacity is also important in that, because you are saying, I have thought about what it is that I'm doing, and as such, this is what I suggest should be done. Yeah.
In our earlier conversation, you spoke about how sometimes in the instance of property, say I'm renting out, or I need to be leasing a house, right? So in this context, what is the process? Do I need to just give somebody or document with other people there? What's the process?
So that's another, requirement of having a valid will. When you sign your will, your witnesses have to be present. They have to physically be there when you sign the document. So they are witnessing that on such and such a day, we were present when Refilwe was signing this document. The implication of that is, if there are issues to say, was there duress, which is something that we don't accept during the signing process of a will, because they can be asked, did you get any sense that Refilwe was under duress from her husband to sign this will? Yeah, those things are very important, because that is actually what they are witnessing, that the process was going in a seamless manner according to the Wills Act, right? If you are someone who cannot read, all right, there's a specific way your will be done, right? And this is where now you need to engage your lawyer to assist in that process, because when they sign it also, that person has to, the commissioner also, or the lawyer has to be present to certify that on such and such a day, this person who cannot read or write has this document, and someone else signed on their behalf. And then these witnesses will be there. And then the other thing is, after that, the signing, you have the option of, and you should actually go and file it at the Registrar of the High Court.
We bring the series on estate planning and drafting of wills to a close next time with Refilwe, when we discuss store it safely as the next step. Until then, have yourselves a pleasant evening. Good night.